I'm Professor Delcianna Winders, Director of the Animal Law and Policy Institute at Vermont Law School. I'm going to be discussing the Animal Welfare Act and its oversight of pets or companion animals. For many of us, pets open our eyes to the complexity and richness of non-human animals. I was certainly no exception. As a kid, I routinely brought home stray animals, including cats and rabbits. And as a teenager, I adopted a rat who had been destined as snake food. Sophia went with me everywhere on my shoulder. She went to school with me, to work, on airplanes, and to concerts. When she wasn't out and about with me, Sophia had free run of my bedroom, and she picked one of my desk drawers to build a nest in. When my mom would come into the room, Sophia would come out and greet her. We often have negative connotations about rats, but as Dr. Lori Gruen discusses in her Animal Law Fundamentals presentation on animal law and ethics, rats are incredibly intelligent, sensitive, social animals. They're attached to their own families, and they also bond with humans. Rats demonstrate empathy. This has been known scientifically for a very long time. They're also ticklish. As one neuroscientist said, rats have, quote, a marvelous sense of fun. When we encounter animals as companions, we look at them in a different light. We think more directly about their needs and well-being. As one of my mentors, Donna Haraway, says, we realize they are, quote, significant others. Pets, or companion animals, are also the reason that the Animal Welfare Act was enacted in the first place. Initially, the Animal Welfare Act focused on experimentation and the supply of people's pet cats and dogs to the research industry. But within just a few years of its initial enactment, the Animal Welfare Act was expanded to also cover the wholesale pet trade. This is because it was seen as arbitrary to cover certain animals, including dogs and cats, in one area and not in another. Although it has been expanded over the years and does regulate the wholesale pet trade, as you'll see, there is still a tremendous amount of arbitrariness in the Animal Welfare Act and its approach. Diving into that, I will discuss how the Animal Welfare Act regulates the pet trade. I'll start with the always thorny question of which animals are covered and which animals are denied coverage. This turns not only on what type of animal is at issue, but also what type of facility the animal happens to be located at in any given moment. I'll next turn to a discussion of what the Animal Welfare Act requires for those animals that are covered, and some enforcement problems that have proven particularly challenging in the context of the pet trade, thanks to lobbying by the wholesale pet industry. In wrapping up, I'll discuss some recent promising developments and opportunities to get involved and be part of the solution. To understand how the Animal Welfare Act applies to pets, we have to answer the first question of which animals are covered. This is the threshold question in the context of any animal law, and it is complicated in the context of the Animal Welfare Act. In determining which animals are covered in the pet trade, there are two components. First, we have to look at what kind of animal is at issue, what species. And that's what I'll talk about first, but that's not all. The next thing we have to look at is where the animal is located, what kind of facility they're at. Because whether or not an animal is protected under the Animal Welfare Act can change depending on where they happen to be located. Turning to the question of species. Americans keep a wide variety of animals as companions. According to the American Veterinary Medical Association, more than half of American households, 57%, have a pet of some kind. Dogs are consistently the most popular animal, and dog ownership is at an all-time high and likely growing because of dogs who've been taken in during the pandemic. At last assessment, the AVMA estimated nearly 77 million pet dogs in the United States. But Americans also keep almost as many pet fish, and this is a growing area of pet ownership. We keep 58 million pet cats, and we keep about 1 million pet horses, although this number is declining. There are also other types of animals kept as pets, and these categories are growing in popularity. More than 6 million reptiles are kept in American households, such as iguanas, geckos, bearded dragons, turtles, tortoises, snakes, and others. Amphibians, like frogs, are also kept, as are birds, and many different types of so-called pocket pets, small mammals, like my rat Sophia, as well as mice, gerbils, hamsters, chinchillas, and so on. Then there are the large wild animals who are kept as purported pets, including lions, tigers, bears, and monkeys. These animals make very poor pets. They're dangerous. They do not do well in captivity, particularly in private hands, but they are kept as pets. We don't know exactly how many of these animals are kept due to the lack of legal oversight. We do know that there are more tigers in private homes in the United States than there are left in the wild worldwide. But estimates of exactly how many range from anywhere from several thousand to as many as 15,000. Not all of these animals who I've just mentioned are considered animals within the meaning of the Animal Welfare Act. As discussed in detail in my Animal Law Fundamentals presentation giving an overview of the Animal Welfare Act, the Animal Welfare Act limits the definition of animal to warm-blooded animals. Warm and cold-blooded are outdated categories that are no longer used by scientists. These categories do not adequately describe the variations and complexity of temperature control in nature we now understand. Some animals simply defy these categories. There's the opa, a deep-water predatory fish who, at least sometimes, is warm-blooded. Bumblebees also show characteristics of both cold and warm blood, as do some species of squirrels and bats. But even more important than the lack of scientific foundation for this categorization is the fact that it has no relevance whatsoever for the question of whether or not an animal needs legal protection. It's well documented that both so-called warm and so-called cold-blooded animals are sentient, they feel pain and joy, they have complex needs. To give one example, a study of iguanas and turtles found that they experience increased heart rates, a recognized sign of stress, when handled by human beings, even when that handling is gentle. They did not show any behavioral signs of stress, so it would be difficult for the human handler to understand that the animal was suffering, which points to a need for more, not less, legal oversight. There's similar available evidence for a wide range of other cold-blooded, so-called cold-blooded species. And they're not only sentient and complex and uniquely intelligent. For some, particularly fish, they're also deeply social animals. Studies have found that some species of fish are so deeply social that they will choose to subject themselves to pain in order to be around others of their species. They would rather suffer pain than be alone. It seems that the more different animals appear from us on the surface, the less likely we humans are to relate to them, to extend compassion to them, and to protect them. But science is showing us more and more every day that even animals who are very different from us on the surface experience the world in ways that entitle them to moral and legal consideration. Animals who are less like us often have more complex and harder to understand needs, and we are less able to read or understand their experiences. And this should point to more, not less, legal protection. But the Animal Welfare Act does not protect these animals. And without amendment by Congress, it cannot do so. As a result, there is a vast unregulated trade in so-called cold-blooded animals. For example, PETA conducted an undercover investigation of U.S. Global Exotics in Arlington, Texas. U.S. Global Exotics was one of the largest suppliers of exotic animals to distributors as well as directly to pet stores in the world. U.S. Global Exotics shipped to suppliers who then in turn supplied Petco and PetSmart stores, and U.S. Global Exotics directly supplied numerous Petland stores. What PETA's undercover investigation found was tens of thousands of animals, many of them unregulated, so-called cold-blooded animals, suffering. This included frogs, lizards, salamanders, snakes, tortoises, turtles, who were confined to filthy, crowded conditions. Approximately 80% of these animals were grossly sick, injured, or already dead. U.S. Global Exotics was throwing away thousands of dead and dying animals, mostly reptiles, every single week. A published peer-reviewed study found that there was a 72% mortality rate at this supplier. This very high mortality rate doesn't even account for the many animals who die by the thousands in transport every step of the way, before reaching suppliers like U.S. Global Exotics, en route to other intermediate suppliers or distributors, en route to pet stores, at pet stores, and in homes where it's been documented that there are also high mortality rates of these types of animals. Warm-blooded animals are covered, but there are two important nuances that I wanted to flag for you with regard to warm-blooded animals. First, horses, though their blood is certainly as warm as yours or mine, are not covered when they're used for the pet trade. The Animal Welfare Act only considers horses to be animals when they're used for experimentation, despite the fact that horses are very important to Americans and very beloved pets. Then there's the particularly tricky category of birds, who are certainly warm-blooded, certainly sensitive, incredibly intelligent. Scientists have remarked on birds' ape-like intelligence and referred to them as feathered primates. I don't mean to suggest that intelligence is necessary for an animal to have moral or legal consideration, but we should certainly take pause if we're denying these incredibly complex, intelligent animals basic legal protections. Birds use tools. Birds communicate, including with unique dialects. According to scientists, some birds, particularly parrots and corvids, who are crows, ravens, and jays, appear to be cognitively superior to apes in many cases. There's Alex, the African gray parrot, who animal psychologist Professor Irene Pepperberg worked with for many years. Alex demonstrated the ability to form abstract concepts, such as same and different. Dr. Pepperberg trained Alex to label vocally more than 100 different objects and to identify them by color, shape, size, and material, to be able to compare them by these categories and to quantify the numbers of them. But it's not just parrots. Scientists have documented cognitive complexity in a wide range of birds. There are other warm-blooded animals who are excluded from the Animal Welfare Act's protection when they're used for purposes like experimentation, such as rats like my pet rat, Sophia, but still covered when used for pet trade. Animals who would be excluded from protections if they were used as food are protected when used for the pet trade. So despite interest in reducing arbitrariness in the Animal Welfare Act by expanding its protections to the pet trade, there's still a tremendous amount of arbitrariness embodied in the statute. Sophia is an animal if she's bred for the pet trade, but not if bred for experimentation. She's also not considered an animal under the law if she's bred for snake food, which is, in fact, what was the situation. So she was not protected before she came into my home. So looking at the type of animal is a key and complicated threshold question to determine whether an animal is protected in the pet trade by the Animal Welfare Act. But that's just the beginning of the analysis. The next thing it's necessary to look at is the type of facility that the animal happens to be located in any given moment. After species, the next question that it's necessary to look at to assess whether a pet is regulated by the Animal Welfare Act is the location of the animal, what type of facility it is currently being held at. Of course, the location of an animal doesn't affect its welfare interests, but it does affect whether or not it's entitled to legal protections under the Animal Welfare Act. The Animal Welfare Act requires that dealers of animals for the pet trade be licensed, but it excludes from the definition of animal dealer retail pet stores. The Animal Welfare Act does not define the phrase retail pet store. Instead, it leaves that to the U.S. Department of Agriculture. Retail generally means selling directly to a consumer. So pet stores, of course, are retail businesses. Petco, PetSmart, Petland, and local smaller pet stores do not need to be licensed by the USDA. They're retail pet stores. By regulation, the U.S. Department of Agriculture has also defined those who sell animals directly out of their homes to consumers to be retail pet stores. These are not stores in the normal sense of the word, and there was litigation challenging this loophole as there were concerns about the lack of oversight if people were keeping these animals in their homes and sometimes not even welcoming consumers in, but instead meeting them at a parking lot. But that litigation was ultimately unsuccessful, and the U.S. Court of Appeals for the D.C. Circuit, held that the USDA was within its discretion in saying that selling an animal out of your home makes you a retail pet store and exempts you from Animal Welfare Act oversight. So pet stores, including those who sell out of their home, are left to state and local governments to oversee, and there's a patchwork system of oversight in place. Pets in private homes, of course, are not covered by the Animal Welfare Act. So the Animal Welfare Act is focused on the wholesale pet trade, meaning those who sell animals at quantity to resellers. This has posed some tricky questions with the rise of internet sales of pets. This is an example of the law needing to evolve in response to new and unanticipated technology. Internet sales of pets has become a booming industry, with people ordering dogs and other animals online, never seeing the facility that they come from, only seeing the handful of select photos posted on a website, and then picking up the dog unattended by any person, often sick, from a crate at an airport. Since there is no middleman, and the dog is technically purchased directly from the supplier to the consumer, this is considered a retail sale. The USDA Office of Inspector General noted that the USDA's treatment of internet sales as exempt retail pet stores was a, quote, massive loophole in oversight. More than a decade after internet pet sales started booming, in 2013, the USDA did finally revise its definition of retail pet store to no longer include internet sales. So those selling pets online over the internet do now need to be licensed by the USDA and inspected for minimum compliance with animal welfare standards. Returning to wholesalers who supply pet stores and other intermediaries, there's another exemption that it's important to be aware of, and that's what's referred to as the de minimis exception. By regulation, the USDA has provided that if you hold 4 or fewer breeding females and you only sell those animals' offspring, you do not need to have a license under the Animal Welfare Act. For those that are covered by the Animal Welfare Act in supplying the pet trade, the USDA divides them into 2 categories. The first they call Class A licensees. These are breeders, those who are breeding animals on site. The second are Class B licensees, referred to as dealers, who are intermediaries, middlemen, brokers, sometimes auctions. They buy and resell animals, often without ever taking physical possession of the animals, without holding the animals for any period of time. But they too are regulated by the Animal Welfare Act. Currently, there are nearly 3,000 Class A breeders licensed and about 750 Class B dealers. So what does it mean for these entities to be regulated? What do they need to do to be licensed and to maintain that license? That's what I'll turn to next. Whether characterized as a Class A breeder or a Class B dealer, those supplying the pet trade must be licensed under the Animal Welfare Act and inspected for compliance with minimum welfare standards to maintain and obtain that license. The specific standards vary depending on the type of animal at issue. Today, I'm going to focus on dogs, America's most common pet. The standards for dogs are more rigorous than for most other animals used for the pet trade, though they tend to be quite similar. The Animal Welfare Act does not dictate what needs to be required for humane care and treatment of animals for the pet trade. Instead, it defers to the U.S. Department of Agriculture to make that determination. The Animal Welfare Act simply directs the USDA to address basic things like food, water, sanitation, ventilation, and vet care. In the case of dogs, the Animal Welfare Act does also require attention to their exercise needs. That is not required for any other type of animal under the law. The USDA has promulgated regulations that contain the bare minimum welfare requirements. I'm going to go through some of those requirements for dogs. First, space. The regulatory requirement for dogs for space is as follows. Find the mathematical square of the sum of the length of the dog in inches, measured from the tip of its nose to the base of its tail, plus 6 inches. Then divide the product by 144. The calculation is length of dog in inches plus 6 times length of dog in inches plus 6 equals required floor space in square inches. Required floor space in inches divided by 144 equals required floor space in square feet. That is a very long way of saying that a dog needs to have about 6 inches more than their body size to themselves. That is all that the Animal Welfare Act requires for space for dogs. They also need to have 6 inches taller than their height standing up. This might sound scientific, but at best it's pseudoscientific. It's not rooted in any science. Science would not support keeping dogs in cages, period. Instead, the USDA says this is based on, quote, common sense. But my common sense tells me to never put my dogs in a cage, and certainly not a cage that small. This 6 inches bigger than their body size requirement barely gives dogs enough room to turn around or to find a clean spot to lie down in. And the bigger the dog is, the less 6 inches is going to mean to them. This lack of space causes stereotypic abnormal behaviors in dogs, which are recognized signs of poor welfare, such as circling, repetitive grooming, and self-biting. Turning to the flooring of the cages that these dogs live in. Breeders for the pet trade typically keep dogs in cages that are suspended above the floor with wire or mesh flooring. These cages are stacked one on top of the other, so there are tiers and rows of dogs, and feces and urine can fall down through the slats in the wire or mesh. The Animal Welfare Act regulations say that dogs' feet and legs are supposed to be protected from injury and that their feet are not to be allowed to fall through the slats. But it only requires that the strands of the wire flooring be more than 1/8 of an inch in diameter, or 9 gauge. As journalist Rory Kress describes in her book, The Doggy in the Window, this is comparable to the lower note string on a bass guitar. This is not very wide. And standing on this sort of wire causes a range of painful and problematic issues for dogs. It damages their paw pads, causing sores, cuts, cracks, bruising, which is not only painful, but also puts them at risk of infection. Dogs also splay their feet out to try to balance on the wire or mesh flooring, which can cause cysts between their toes and other painful conditions, and yet more risk of infection. This also affects their gait and ultimately can cause skeletal problems. Unable to wear down their nails, dogs' nails can curve into their paw pad and become embedded, which is not only painful, but can become potentially life-threatening. Dogs' feet can also become trapped in wires, and their nails can get caught and torn off, causing yet more pain and potential infection. Dogs also may avoid lying down because it's uncomfortable to lay down on wire, and this prolonged standing in turn causes joint and muscle stress. What about the social needs of dogs? We all know, I think, that dogs are extremely social animals. Dogs and humans have evolved together over millennia. Scientifically, we know that dogs do better, both psychologically and physically, when they have social companionship. The USDA does not require that social needs of dogs be meaningfully taken into account. The USDA did consider and reject having such a requirement. And so, in a final rule published in the Federal Register, the U.S. Department of Agriculture said, quote, "We do not believe that it is essential for the health and well-being of dogs that they have sensory contact with other dogs, and do not believe that it is appropriate to include such a provision in the regulations as a required minimum standard." Remarkably, in the same breath, the USDA did say that dogs kept alone, quote, "need regular interaction with humans." But it did not require this regular interaction. Instead, it required a plan to provide dogs who are held in solitary confinement with positive physical contact with humans at least daily. This sounds good on paper, but all that is required is a plan. Nearly half of all USDA inspectors surveyed concluded that the plan criteria is not adequate to actually enforce this requirement. A A 2005 analysis found that the vast majority of citations for violations of this requirement were for a total failure to develop, document, or follow the plan, and said, quote, only rarely was a facility cited for not providing an isolated dog with positive physical contact with humans. More recently, I analyzed more than 5 years of the most recent USDA inspection reports. There was not a single citation for violating this requirement. That is not because all of the dog breeders have suddenly started following the requirement. It's because it's not being enforced. Dogs are routinely held alone, and they are not given even this contact with human beings. The situation with exercise isn't any better. It's truly, truly minimal. If a dog is held alone, as long as they're given double the 6 inches of floor space that they're supposed to have, that is, if they're given 1 foot of floor space, they never need to be let out of the cage. The USDA thinks that gives them enough space to get enough exercise for their lifetime. If dogs are held in groups, as long as each dog has at least the 6 inches, they never need to be let out either. So the only time dogs need to be let out for exercise is if they have less than these very minimal space requirements. And even then, there's no detail provided on what that exercise must look like. It's not specified how frequent it needs to be, how long it needs to last, or what it needs to look like. Instead, that decision is left to the veterinarian who is employed by the very breeder or dealer that the USDA is regulating. The veterinarian is also given the authority to exempt dogs from the exercise requirement. So the USDA has nearly wholesale delegated its responsibilities to someone who is on the payroll of the very entities it's supposed to be regulating. Nor are there restrictions on breeding. There are no limits on how young a dog can be when you start to force her to breed. So the incentive is to start as young as possible to maximize profits, even though it's known that forcing a dog to breed too early can lead to health problems. There's no limit on how frequently a dog can be bred, in a year or in a lifetime. So breeding female dogs for the pet trade become exhausted and spent. They're used entirely for their reproductive capacity, and the continual nursing and pregnancy causes calcium deficiency, resulting in missing teeth and other dental issues very frequently. Nor is there any requirement to protect against breeding dogs for heritable health defects. It's well known that purebred dogs, who are by definition inbred, can suffer from a host of health problems. These problems cause harm to animals, and they can be very costly to the humans who buy those animals. Hip dysplasia is a common example, but there are more than 300 other known disorders that are from inbreeding. The USDA doesn't limit this in any way. Nor are there any retirement or end-of-life requirements for dogs used for the pet trade. Once an animal is no longer profitable, they can be discarded at will. Spent female breeding dogs, once they no longer are breeding at a profitable level, can be killed. But also puppies who have irregularities or undesirable characteristics. Maybe they just don't quite look how a purebred dog of their breed is supposed to look. A breeder or a dealer is perfectly within their right under the Animal Welfare Act to kill all of these dogs. And it doesn't need to be a veterinarian who kills them. The Animal Welfare Act requirements simply say that there needs to be adequate guidance provided to personnel on humane euthanasia. There's no explicit prohibition on shooting dogs in the head, and as a cheap, easy method, it's often used. So under the Animal Welfare Act, dogs in the pet trade are given the bare minimum. They're given enough to survive as long as they're profitable, nothing more. And once they're no longer profitable, they can be disposed of at will. And if anything, dogs get more than other animals in the pet trade. The requirements for other types of animals are less. The situation is the worst of all for the female dogs used for breeding, who never get out of those stacked, tiered cages, who may never be pet, who may never have the company of another animal or a human being. They'll briefly have their puppies until they're taken away from them and they're impregnated yet again. And then when their body is spent, they're killed and thrown away and replaced with another. These are truly minimal requirements, but they are still violated with some frequency. And so next, we'll look at what happens when they're violated and what the USDA does to enforce and protect these animals from at least these sorts of egregious harms. The Animal Welfare Act has been consistently plagued with enforcement issues since its enactment in 1966. Enforcement failings have spanned decades and presidential administrations, and they continue to this day. I discuss these issues in detail in my Animal Law Fundamentals presentation, giving an overview of the Animal Welfare Act, and I'm not going to repeat that here. Instead, I'm going to focus on how these issues play out in the context of the pet trade and some specific issues that have arisen in this context. The issues that I flag in that presentation, including the over-reliance on meaningless warnings as a primary enforcement tool, severely discounting potential fines to just pennies on the dollar, and automatic renewal of licenses for even the worst abusers, all plague the pet trade. They might be even most prevalent in the context of those supplying the pet trade. One U.S. Department of Agriculture Office of Inspector General audit focused entirely on dog breeders, and it concluded that the USDA's, quote, enforcement process was ineffective in achieving compliance. It went on to note that, quote, the agency continued to assess minimal penalties that did not deter violators. A very recent follow-up to that audit report was unable to get very far. Instead, the Inspector General concluded that the USDA's own inspection data was, quote, unreliable. So they were not even able to assess compliance with the previous recommendations or to determine whether the USDA had made improvements. According to the Office of Inspector General, the USDA could not generate complete data sets of its own inspections for the Office of Inspector General. And every time the USDA attempted to generate data sets, it generated a, quote, different incomplete data set. So the very system that the USDA is relying on for its implementation of the Animal Welfare Act is unreliable. And this is also, of course, the system that the public relies on to monitor things and that Congress relies on. In that recent audit report, the Office of Inspector General concluded that the USDA, quote, is not able to ensure the overall health and humane treatment of animals. That is, of course, the purpose of the Animal Welfare Act. It's very important to know that the U.S. Department of Agriculture has never wanted responsibility for the Animal Welfare Act and has sought to get rid of that responsibility. The U.S. Department of Agriculture is an agency whose primary mandate is to promote agriculture, including animal agriculture, to help farmers. And the USDA sees itself as a service-providing agency. The USDA refers to the breeders and dealers and others that it regulates under the Animal Welfare Act as, quote, customers, to whom it provides, quote, services. The USDA also sees the entities it is supposed to regulate as collaborators, and it has repeatedly insisted on cooperating with violators of the law rather than enforcing the law. The USDA has gone so far as to suggest that, quote, collaborating with regulated entities is the best way to ensure compliance. And this is despite a previous Office of Inspector General finding that the USDA's belief that compliance can be achieved through education and cooperation would result in long-term compliance has proven ineffective in achieving compliance with the Animal Welfare Act. The Office of Inspector General also concluded that such a cooperative approach has, quote, weakened the agency's ability to protect the animals. According to the Office of Inspector General, rather than prevent situations from worsening, the USDA's cooperative approach has caused a failure to take action while violations escalated to serious and grave levels, directly affecting animal health. These Inspector General conclusions are consistent with my own recent findings. Some of these are discussed in detail in the Animal Law Fundamentals Animal Welfare Act overview, including the USDA's reliance on warnings that are ineffective at achieving deterrence. For example, in my Ohio State Law Journal article, critiquing the USDA's reliance on warnings and its assertion that they are able to swiftly bring violators into compliance, I open with an example of a Missouri-based dog breeder who the USDA slapped with a warning after a host of serious Animal Welfare Act violations. After receiving this warning, this dog breeder continued to violate the law, and the USDA issued a second warning. The dog breeder continued to violate the same legal requirements. For example, an inspector observed that he was not providing shade for dogs who were, quote, panting heavily and had lolling tongues in 127 degrees Fahrenheit. On another occasion, an inspector observed that dogs were not given any shelter from wind, rain, or snow when wind chill was 16 degrees Fahrenheit. At this time, the inspector observed a dog who was shivering and holding up his paws. The USDA also documented this dog breeder failing to provide veterinary care to dogs who had a host of painful conditions, including nails growing into the pads of their feet. Dogs were held in an enclosure where 85% of the ground was covered in feces. In short order, after the warnings were issued, the USDA documented dozens of violations of the minimum animal welfare standards for dogs, and it took no further action. It also continued to renew this breeder's license to breed animals like clockwork, year in and year out. This is standard. This is how the USDA handles, or more accurately, fails to handle, violations of the Animal Welfare Act. There's an added layer that has developed in recent years. In response to the USDA's failure to do anything, even when it documents violations of even the most minimum requirements, local and then state governments have started to adopt laws that condition the sale of animals within their borders for pets on compliance with the Animal Welfare Act. So they rely on Animal Welfare Act inspection reports, recognizing that although the USDA might not do anything, they can take this data and make a determination about whether or not that breeder or dealer will be allowed to supply dogs or cats to their jurisdiction. So these laws vary, but they have limits on how many violations or the types of violations that a breeder or dealer can have if they're going to be allowed to sell within a particular jurisdiction. The pet industry complained to the USDA about these laws and said that the USDA's inspection reports were interfering with its business and its ability to sell animals. Rather than perhaps suggesting that these violators of the law come into compliance to avoid this problem, the USDA officials agreed that it was a problem and that it was a problem that the USDA, not the law violators, had responsibility to address. The USDA reportedly stated that it had the responsibility, quote, to enable breeders to sell their dogs to pet stores, and suggested that violations are an impediment to such sales. And so, in 2014, at a USDA conference for breeders, the USDA announced its new Teachable Moments policy. The Teachable Moments policy provides that some violations of the minimum standards of the Animal Welfare Act will not be included on inspection reports. That an apparently clean inspection report will be posted online and made available to those who seek to look at it. And on a separate document that is not public, that is not available under the Freedom of Information Act, other violations would be documented. Thus, the state and local governments would be unable to reference these violations in enforcing their laws. It would be more than a year from this announcement at the breeder conference before the USDA informed the public of this new policy. And it was only after pressure from advocacy organizations who'd caught wind about it. When I asked the head of the USDA's Animal Care Division why it was posting inspection reports that falsely stated that no violations had been observed, when we knew there were violations documented in Teachable Moments forms, she said to my face that it was to protect licensees from, quote, disparagement. Under the USDA's Teachable Moments policy, Teachable Moments are only supposed to be used for certain types of violations. They're only supposed to be used for minor violations that are not harming animals. They're only supposed to be used for violations that haven't happened in the recent past previously. But the USDA Office of Inspector General has concluded that the USDA is not using Teachable Moments consistently and that it is not properly documenting teachable moments. My analysis has found that the USDA isn't even following its own guidance when using teachable moments. And so it is using teachable moments despite recent violations of the same requirements, and sometimes even when animals are suffering as a result of the violation. Thanks to legislation that I worked with a coalition of organizations on, Congress has required the USDA to post the teachable moments documents online. Litigation also helped secure this result. But teachable moments are still kept separate from the regular inspection reports, which for decades have been the go-to resource for assessing whether or not a facility is compliant with the Animal Welfare Act. And inspection reports, even when there are teachable moments documented, continue to make it seem as if a facility was in perfect compliance. Next, I'm going to turn to a discussion of some things that we can do to help address this situation and the USDA's failure to protect animals used in the pet trade. To summarize, shortly after its passage in 1966, the Animal Welfare Act was amended in 1970 to also protect animals in the pet trade. But it does not protect all animals in the pet trade. The threshold question of which animals are covered turns both on what kind of animal is at issue and where the animal is located. There are millions of animals in the pet trade, including fish, amphibians, and lizards, who are not covered by the Animal Welfare Act because they are not what is called warm-blooded. Although warm-blooded, horses are excluded from the Animal Welfare Act. For covered species, it's necessary to then look at where they happen to be located. And that's because the Animal Welfare Act focuses on the wholesale pet trade, those who are supplying not directly to consumers, with the exception of internet sales, but rather supplying animals in quantity to others who then distribute them to consumers. For that relatively small category, there's a need to be licensed as either a breeder or a dealer and to comply with minimum standards. But as I've discussed, those standards are incredibly basic. They provide for what an animal needs to survive, not more, and they allow an animal to be killed and discarded once they are no longer profitable. I focused on the standards that are specific for dogs. Other animals have different but very similar standards, and if anything, they're less rigorous than those provided for dogs. And even when these minimum requirements are violated, the USDA fails to take enforcement action. It automatically renews licenses. And it has even gone so far in recent years to thwart state and local law enforcement from protecting animals within their own borders by removing information that they relied on to ensure that animals sold within their borders were coming from minimally compliant facilities. There's a lot that needs to change to address this situation. In my Animal Law Fundamentals overview of the Animal Welfare Act, I go into detail about some major changes that are needed to improve enforcement of the Animal Welfare Act. I'm not going to repeat those recommendations here, although they're extremely relevant for animals in the pet trade. Here, I'm going to focus on some additional steps that we can take that are specifically focused on the pet trade. First, in 2015, the Humane Society of the United States and the American Society for the Prevention of Cruelty to Animals submitted a petition for rulemaking to the USDA, asking it to improve its regulatory requirements for dogs to address many of the issues that I've talked about today, including space, stacking, social needs, exercise, breeding, retirement, and more. In the intervening years, the USDA has not acted on this petition. So an important thing that needs to happen is pressuring the USDA to promulgate better, more meaningful, and science-based standards for dogs. You can urge your members of Congress to pressure USDA to do this and make it known to the USDA that as a consumer, you want better oversight. But getting the USDA to act is an uphill battle. And there are other things we can do while we're waiting for that long game. I mentioned that state and local governments have started to step in and to try to help these animals, and that they were conditioning sales within their borders on certain compliance with the Animal Welfare Act. A number of local jurisdictions, and now some states as well, are taking a much more easily enforceable approach. They're simply banning the retail sales of certain animals within their borders. There's no conditioning on Animal Welfare Act licensure or information from inspection reports. You simply cannot sell these animals within their borders. Instead, they're encouraging adoption of the many, many animals who are in shelters. Typically, these laws focus specifically on dogs and cats and sometimes rabbits. When I was a fellow in Harvard's Animal Law and Policy program, I had an opportunity to apply my Animal Welfare Act scholarship by working with the vice mayor of Cambridge, Massachusetts, on an ordinance that went further. The vice mayor had heard about other localities enacting these laws and was interested in doing something in Cambridge as well. Cambridge has long been a leader in local ordinances to protect animals. When we met with him, I suggested that perhaps we go further, that we ban the retail sales of all animals for pets. I explained to him that although, yes, the situation is dire for cats and dogs and rabbits, it's actually worse for other animals like lizards and amphibians and fish who are not even regulated by the USDA, who are not inspected, who are not licensed. The vice mayor had had an iguana growing up, and he was sympathetic to the ask. And I think this is a really good example of asking and seeing what happens. The worst that can happen is they say no. And a number of times now, I've had lawmakers be willing to do something simply because I asked. They hadn't thought about it before, and they were willing to go further than they were initially thinking of. So we worked together. I brought in evidence from PETA's undercover investigation of U.S. Global Exotics and other facilities. And despite opposition from pet stores like Petco and PetSmart, which continue to sell lizards, so-called pocket pets, and other animals, despite no longer selling cats and dogs, we were able to successfully enact the furthest reaching retail pet sale ban in Cambridge, Massachusetts. Other localities can follow suit and protect not just dogs, cats, and rabbits, but all animals in the pet trade in their jurisdiction. And this is something that anyone can do. You don't need expertise. The dozens of local laws protecting animals in the pet trade that have been enacted across the U.S. at the local level have been thanks to local citizens who stepped forward and reached out and were able to accomplish something. So this is something any one of you can do. Finally, take responsibility and make sure that you're not a part of the problem. You've taken a really important step by watching this presentation today and educating yourself and understanding the limits of the USDA's oversight of animals in the pet trade. You can now act on that. You can adopt rather than shopping for an animal. You can adopt one of the millions of animals who are in shelters across the US, many of whom are euthanized every year simply because no one takes them into their homes. And instead, they buy an animal from the pet trade, despite the USDA's lax or non-existent oversight of these facilities. You can do your part to make sure you're not complicit in this industry, and you can also educate others. No one wants to be responsible for harming an animal. No one wants a puppy from a mother who has never felt grass under her feet, has never been pet by a human, has never even been let out of a cage. And if we raise awareness about this, we can change the situation, even if the U.S. Department of Agriculture won't. This is Delcianna Winders for Animal Law Fundamentals.